Yes.
May it please this
Any other
honorable court.
appearance?
Yes, my lord. May it please this honorable court. Mrs. Itohan Richard. I only appear for the first respondent. Mrs. Itohan Richard for the first respondent.
Yes. Any other appearance? Any other appearance? I take it that there is no representation for the second and third defendants.
Respectfully, my lord, I am still in a chair.
But I've been asking, why didn't you respond in time?
For the sorry, my lord, I didn't know my call was muted.
So your name is who again? Who is appearing for second and third defendants?
See Oyena chair. My humble appearance for the second and third defendant, my lord.
Very well. This is my judgment. I have given due consideration to all the processes and submissions of the parties. Two issues are before the court: the defendant's preliminary objections and the claimant's originating summons. I shall treat the first defendant's preliminary objection first, and then second and third defendant's preliminary objection before looking into the claimant's originating summons. And this will be so even if the defendant's preliminary objection succeeds, since courts below the Supreme Court are enjoined to resolve all issues brought before them. You can see that in Dingadi and another versus Enoch, Idigbe versus APC and others, and Okafo versus Abu Mufuani. The citations are in the judgment. So I'm starting with the decision on the preliminary objection. The first defendant's first ground of objection is that the claimant's suit, being incompetent, should be dismissed or an order striking it out. That alternatively, in the event that this court is willing to allow the claimant use the affidavit and written address accompanying the claimant's originating summons filed on 2nd October 2020 as the processes in support of the claimant's amended written address filed on 11th December 2020. Then, secondly, this court lacks the jurisdiction to entertain the claimant's suit, having been initiated by way of originating summons when the facts are hostile and contentious. That contrary to the provisions of Order 3, Rule 17.1 of the NICN Rules 2017, the claimant's amended originating summons was not accompanied with an affidavit setting out the facts relied upon to sufficiently identify the cause or causes of action. Copies of the instrument indicating part sought to be construed and other related documents and a written address containing the issues to be determined were not filed along with the amended originating summons. Counsel cited Diamond Bank versus Transfer International Limited and another. which held that when an originating process is incompetent, nothing can be done to validate it. He also cited Ezia and another versus Guanyi and others. The citations are in the judgment. That the failure of the claimant to comply with the provisions of Order 3 Rule 17.1 of NFCN rules is a fundamental nature and as such, this court cannot shut its eyes to it or treat it as a mere irregularity. Second and third defendants' first ground of objection, which is the same as first defendant's alternative objection, challenging the court's jurisdiction, will be taken together. To the claimant, Order 3 Rule 17.1 of the court's rules cited by the first defendant is irrelevant and inapplicable in the instant suit, as same is the general requirements for the commencement of actions, nay, originating summons before this court, that there is no obligation on his part for him to refile the affidavit in support of the originating summons, the written address, together with the list of authorities, as well as the exhibits attached to the originating summons that were filed pursuant to the originating summons. That there is a difference between pleadings and accompanying documents filed along with the pleadings, that any of them can be amended or substituted independently of the other as provided under Order 26, Rule 1, Sub Rule 1 and 3 of the NICN Rules 2017. Cited the case of Olanian versus Oyewole. The citation is in the judgment. On amendment of court processes / pleadings, the Court of Appeal heard in Dunalin Investment Limited versus BGA PLC and another, Augi JCA, now JLC does. The citation is in the judgment. I'm quoting Augi now. Ekpong, quote, Ekpong versus Etu, where Garba, JCA, aptly observed, the appellants are not challenging the exhibits on the ground that they have not pleaded, that they were not pleaded by the first respondent or any of the parties to the petition. Their only quarrel with the exhibits is that the first respondent did not again annex or attach or accompany the amended reply with the exhibits. The learned counsel did not cite any portion of the first schedule of the Electoral Act or any judicial authority which requires that a respondent or a party who amended his pleading had the duty to again accompany the amended pleading with the documents, list of witnesses, and statement on oath, which had earlier accompanied the initial or original pleadings amended. There is no such requirement in law that would support such a position. This is because an amendment is not an abandonment or withdrawal or even substitution of the pleadings amended from the proceedings in a case. Even in ordinary everyday English language, the word amendment does not mean replacement or changing completely the initial or original pleadings. My learned brother Garba JCA may have made this observation while dealing with an election petition in Ekpong versus Etu, Supra. But this reasoning makes perfect sense when applied to this appeal. An amendment dates back to the date document amended was filed, and the action continues as though the pleadings had been in the original form right from the original date. See Oguma versus IBWA, Ezinwa versus Agu, Obasan and another versus Abudu and others. The citations are in the quotation, and I close the quote of the learned justice of the Court of Appeal. Now, JSC. In Nagogo versus CPC and 7 others, the citation is in the judgment. The Supreme Court heard Peter Odili, JSC, thus. I am quoting Peter Odili now. The supporting affidavit of the second respondent as plaintiff was amended sequel to an application to court and an order accordingly. Therefore, the valid supporting affidavit of the second respondent is that after the amendment of the originating summons, which stated fuller facts, but not substantially different from the earlier supporting affidavit. And to be relied upon, I hereby refer to the guide provided by the court per Adekeye JSC in Anambra State Environmental Sanitation Authority versus Equenem, citation is there, which decision adopted and applied the earlier position of this court in Agbahonowo versus Duyegbe, wherein it was stated per Igu JSC as follows, quote, there can be no doubt that once pleadings are duly amended by the order of court, what stood before amendments are no longer defined the issues to be tried before the court. See Warner versus Sampson. The clear principle is that such original pleadings which had been duly amended is no longer material before the court. Not that it no longer exists. It does certainly exist and is before the court. It is, however, totally immaterial in the determination of the issues to be tried in the proceedings. It thus cannot be considered as the basis of one's case in any action. Nor may a court of law rely on any such original pleadings, which has been duly amended as the basis for its judgment in the suit. The issues to be tried will depend on the state of the final or amended pleadings. See Salami versus Oke and Baisi and others versus Bikorefe and others. The citations are in that quotation. I close the quote. Order 3 Rule 17 of the NICN Rules 2017 makes provision for documents to accompany originating summons. The proviso to the rule is that where a suit raises a substantial dispute of facts or is likely to involve substantial dispute of the facts, it shall not be commenced by way of originating summons, but by complaint provided for in Rules 8 and 9 of this order. The law is that where a rule or law enjoins the doing of a thing, but did not provide any sanction for not doing the thing, such a rule or law is merely directory, not mandatory. See the Supreme Court decision in Bode Thomas versus FJSC, the judgment of which was delivered 16 February 2018. The argument of the first, second, and third defendants that failure of the claimants to comply with Order 3 Rule 17 Sub Rule 1 of NICN Rules 2017 is of fundamental nature, is not sustainable, and so is hereby rejected, and I so hold. It is first defendant's contention that the claimant commenced this suit by way of originating summons in gross violation of Order 3, Rule 3 of NICN Rules 2017, that originating summons is usually used when what is in dispute is the mere construction of documents or interpretation of law. The cited Incorporated Trustees of All Farmers of Nigeria and another versus Akman and others. That facts leading to the termination of the claimant's appointment are quite contentious, and this makes the commencement of this suit by way of originating summons inappropriate. Cited Nemi and others versus the state, that failure of the claimant to initiate this suit by due process of law has robbed this court of its jurisdiction to entertain same. In the Trustees of the Nigerian Institute of Estate Surveyors versus Tsudo, the Court of Appeal heard per Iyizoba JCA as follows. I'm quoting Iyizoba now. The case of Nagogo versus CPC, Supreme Court heard that the manner or form of commencement of an action is not by itself enough to vitiate an action if the ends of justice would be compromised on account of such technical application of the rules. The objection of the appellant to competence of this action on this score is not meritorious and is hereby overruled. In Ogugu versus the state, the Supreme Court heard that the provisions of Section 42 of the 1979 Constitution of the Federal Republic of Nigeria for enforcement of fundamental rights is only permissible and does not constitute a monopoly for the enforcement of those rights. Muhammad Bello, CJN, emphasized that the section does not exclude the application of the other means of enforcement of fundamental rights under the common law, statutes, or rules of court. Close of quote. In determining whether the facts in support of the originating summons are contentious It is the nature of the claim and the facts deposed to in the affidavit in support of the claims that shall be examined to see if they disclose disputed facts. It is not to oppose the claims in an originating summons that determines whether the proceedings is hostile in nature. See Jimo versus Alation. You said that the facts leading to the termination in his written address. Therefore, the first defendant therefore, the first defense is contentious and or improperly initiated. And I so hold. The second and is whether the second and third competent have jurisdiction over a matter, proper parties must be identified. That for a person to be joined in an action, he must be someone whose presence is necessary to the suit. That a necessary party is one that is not only interested in the subject matter, but also in whose absence the proceedings cannot be fairly dealt with. Cited Amadi Ume and another versus Ibok and others, Supra, and Ejigbo local government and others versus Adepegba and others, Supra. Second and third defendants are not necessary parties to this suit. That second and third defendants are not necessary parties to this suit, since the claimant has not made any claim nor sought any relief against them. In summation, second and third defendants urged the court to uphold their preliminary objection. In reaction, the claimant argued that it is tried law that the Attorney General of a state or the Federation can be sued in any civil claim or complaint against the government of a state or the Federation, as the case may be, where there is any claim of or complaint against the state or the federal government respectively. Cited Attorney General Kano State versus Attorney General of the Federation, Ezomo versus Attorney General Bender State, Supra. Claimant submitted further that the act of an agent is the act of the principal, which in this suit is the Delta State government, thereby making the second and third defendant necessary parties in this suit. That is why second and third defendants cannot escape legal liability in this suit. Cited CFAX Nigeria Limited versus MIG4 Nigeria Limited, LSBPC versus Purification Techniques Nigeria Limited. The citations are in the judgment. That joining the third defendant in this suit is in the overall interest of the peace, stability, and the economy of the government and people of Delta State of Nigeria. Second and third defendant preliminary objection is binding, is hinged on the argument that because the claimant did not make any claim against the second and third defendants, no course of action against them has thereby been disclosed. As such, the suit is incompetent or ineffectual as against them. Second defendant has been sued in his capacity as the Chief Law Officer, Commissioner for Justice of Delta State, while the third defendant has been sued as the Chief Executive Officer and Head of Delta State Government of Nigeria. It is settled law that the federal or state government can be sued, and in their place, the Attorney General of the Federation or state can be the party, claimant, or defendant. See Attorney General Rivers State versus Attorney General Bayelsa State, and another. Citation is in the judgment. The same rule applies where any of the authorized agencies of government is involved or a government act is called to question versus the absence in the judgment. Still on whether the Attorney General can sue or be sued on behalf of the state, the Supreme Court held in Nigeria Engineering Works Limited versus Turnup Limited and another Pearl Cargo JLC does. I'm quoting Justice Cargo now. But it is not settled and as decided by this court in Ransom Kuti versus AG of the Federation. Ezomo versus Attorney General Bende State, that the Attorney General is a defendant or nominal defendant in civil cases in which the government is sued, in this case, the action of the governor, virtued officio, as a public officer, which makes it a government act, was being challenged in court. This makes the Attorney General a proper defendant in the action. Close of quote. And by Black's Law Dictionary, 10th edition, at page 1801, an officer acts virtued officio when he acts by virtue of the authority vested in him as the incumbent of the particular office. See also Nigerian Engineering Works Limited versus Tenap and another. In Attorney General of Kano State versus Attorney General of the Federation, His Lordship Cargo, JSC, in his concurring judgment, opined that it is not in dispute that the Attorney General of the Federation can be sued as a defendant in all civil matters in which a claim can properly be made against the federal government or any of its authorized agencies, arising from any act or omission complained of. This viewpoint was applied in Registered Trustees of National Association of Proprietors, Private Schools versus Attorney General and Commissioner for Justice, Rivers State. There, however, seems to be authority that where it is a government body that can sue or be sued in its corporate name, then the Attorney General is not a proper party. For instance, relying on Zomo versus AG Bendel State and AG Kano State versus AG Federation, Mukhtar JSC, as she then was, in AG Anambra State versus AG Federation, head thus. Quote, the Attorney General in all civil money can properly be made against the federal government or any of its authorized agencies, arising from any act or omission complained of. The instant case that Attorney General of the Federation is not a cannot be effected against the federal government. Proper body to sue is Independent National Electoral Commission, INEC, which is a corporate body capable of suing and being sued. And another heard that the Attorney General is a proper party to be proceeded against in an action against the federal government and all or any of its agencies. As such, the Attorney General, being a party to the suit, has covered the interest of the applicant, as the applicant, that is FAAN, is an agent of the federal government. And Nigeria Engineering Works Limited versus DENOP, quoted earlier, acknowledged that the Attorney General is a defendant or a nominal defendant in civil cases in which the government is sued. This being the case, the presence of the third defendant in the instant suit, even if nominally, does not thereby make the third defendant an improper party, as counsel to the second and third defendants seem to argue. I accordingly hold that this suit is competent as against the second and third defendants. On the whole, and for the reasons given, the preliminary objections of the first defendant and the second and third defendants, respectively, are baseless and so lack merit. They fail and so are hereby dismissed. Accordingly, I hold that this court has jurisdiction over this suit. I shall therefore proceed to consider the merit of the originating summons. Reading the defendant's respective written addresses in opposition to the claimant's originating summons is like reading their written addresses in support of the notice of preliminary objection. I find it quite detestable that the very issues raised by first defendants and the second and third defendants as supporting their respective preliminary objection are in the main substantially the very issues also raised in opposition to the claimant's originating summons. The question is, why would the defendants file preliminary objection on grounds that they know are substantially the same with those on which they will oppose the merit of this case? This made no sense at all. Why not simply defend the case? It merely places additional workload on the court, having to read repetitive arguments disguised as addresses in support of a preliminary objection and in opposition to the merit of the case is something that should never be encouraged. Not with the avalanche of cases that courts face today. Issue 1 in the originating summons states thus: whether having regard to the clear and unambiguous wordings of Section 4.3, and particularly items 34 and 68 of Part 1 of the second schedule exclusive list of the 1999 Constitution as amended, Section 6 of the Legislative Aids Appointment Law of Delta State 1999 as amended, which prescribes the termination of employment of legislative aides at the pleasure of the members of Delta State House of Assembly without recourse to the process of law, is not inconsistent with Section 4.3 of the 1999 Constitution as amended and the ILO Convention number 158 of 1982 on termination of employment, and consequently unconstitutional, null and void ab initio, and of no consequence. In paragraph 92 of his affidavit in support, the claimant averred that the provision contained in Section 6 of the Legislative Aids Appointment Law of Delta State 1999 as amended is obnoxious, oppressive, unconscionable, undemocratic, unethical, uncivilized, and devoid of the tenets of natural equity and good conscience. And it is in conflict with Section 4, Sub 3 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, the ILO Convention number 158 and of 1982 on termination of employment and other international treaties, labor standards, and connected labor practices, for which the Federal Republic of Nigeria is a signatory and has ratified, and further that this court has the power to declare the section as null and void. In paragraph 3.38 of his written address in support of originating summons, claimant urged the court to hold that Section 6 of the Legislative Aids Appointment Law of Delta State 1999 as amended is conflicting and encroaches on the powers of the National Assembly, particularly with respect to item number 34 of the exclusive legislative list of the 1999 Constitution as amended, and consequently unconstitutional, void ab initio, and of no consequence. I must state here that the strong language used by the claimant in paragraph 92 of his affidavit in support of his originating summons, to say the least, leaves a lot to be desired, and indeed gives a very sour taste in the mouth. It is more demeaning of the person using such uncouth language than against the person to whom it is addressed. Counsel must be mindful of their exalted status as ministers in this hallowed temple of justice. It is the duty of legal practitioners to show utmost respect and to always apply politeness, decent language, and respect in their address, briefs of argument, and to avoid unnecessary or unjustified attack or foul language on either other counsel or on the court or at all. For that, see Federal Housing Authority versus Nuruddin Adewale and Bruce Nigeria Limited. See also Ndukwe versus LPDC, Mokwe versus Williams, and Chukwu versus Enoch. Words like uncivilized should be avoided. By Section 4, Sub 3 of the 1999 Constitution as amended, matters in the exclusive legislative list are set out in Part 1 of the second schedule to the Constitution. It reads, it needs to be noted that there is a little or no controversy on matters contained in the exclusive legislative list, as there is no room for fiction or conflict between the federal government and the state government, since the state governments are expressly excluded from legislating on the matters therein. It will therefore be absurd and unconstitutional for a state to legislate on any matter contained in the exclusive legislative list. The question is, has Section 6 of the Legislative Aids Appointments Law of Delta State 1999, as amended, usurped the powers of the National Assembly as contained in Item 34 of the exclusive legislative list and violated the extant provisions of the ILO Convention 1958 of 1982. Sorry, 158, Convention 158 of 1982. The employment of the claimant by the first defendant, as provided for in Section 6 of the Legislative Aids Appointment Law of Delta State, as amended, in my humble view, is not in deference to Section 43, Item 34, and 68 of Part 1 of the second schedule, that is exclusive list. The defendant can, even without the said law, invite or advertise for applications and terms of engagement of legislative aids, should there be such a need, by features, organ, and others versus Nigerian Liquefied Natural Gas Limited and another. The letter of employment is the bedrock on which any employee of the employer, and without the production of such a document, no employment can be inferred. The employee's handbook issued is not a substitute for the letter of employment either. Article 4 of the ILO Convention number 158 of 1982 states that, quote, the employment of a worker shall not be terminated unless there is a valid reason for such termination connected with the capacity or conduct of the worker or based on the operational requirements of the undertaking, establishment, or service, close of quote. Article 6, sub 1 and 2 goes on to state that, 1, temporary absence from work because of illness or injury shall not constitute a valid reason for termination. 2, the definition of what constitutes temporary absence from work, the extent of which medical certification shall be required, and possible limitations to the application of paragraph 1 of this article shall be determined in accordance with the methods of implementation referred to in Article 1 of this convention, close of quote. And by Article 7, the employment of a worker shall not be terminated for reasons related to the worker's conduct or performance before he is terminated, provided an opportunity to defend himself against the allegation made, unless the employer cannot reasonably be expected to provide this opportunity. The emphasis there is to judex. By paragraphs 27 and 28 of first defendant's deposition, first defendant caused a query to be issued and served on the claimant through his WhatsApp phone number 0806-964-3739, 0705-526-1616. That's the exhibit DW1. That when first defendant did not receive a response to the query, first defendant terminated claimant's employment by the exhibit DW2. Claimant's salary was then stopped. There is, however, no evidence of the electronic service of the query or termination. The claimant's challenge of his termination nevertheless indicates that he was seized of the query and termination. The claimant's grouse is whether first defendant can terminate his appointment at first defendant's pleasure, say terms of engagement notwithstanding. Due process in terms of employer-employee relationship remains sacrosanct and must be adhered to by both parties. And so, notwithstanding the provisions of Section 6 of the Legislative Aid Appointment Law of Delta State, 1999 as amended, that a legislative aid shall vacate office at the pleasure of the member who employed him, the terms and conditions of employment remain the bedrock that determines claimant's employment status. See Fee Charles Organ and others versus NLNG Limited and another Supra. I do not see any inconsistency in the laws cited by the claimant, and I so hold. Issue 2 is whether the community reading of the provision of Section 3 of the Legislative Aids Appointment Law of Delta State 1999 as amended, and claimant's letter of appointment with reference number SGD 147/T13B/150 dated 21st October 2019, claimant is not entitled to the security of tenure of office, simultaneously ending with the tenure of the office of the first defendant. To the claimant, the expression shall employ a legal assistant whose appointment is tied to his tenure in office implies that claimant's employment remains valid till 09/06/2013, when first defendant's second tenure shall elapse. This provision is so sacrosanct that it does not condone nor tolerate any unilateral and unlawful termination without recourse to due process of law in the lifetime of the tenure of office of the holder of the office of a member, the Delta State House of Assembly. Cited Baba versus NCTC Zaria, Union Bank of Nigeria Limited, BU Ume and Sons Limited, and an avalanche of other authorities. The claimant then urged the court to hold that by the community reading of Section 3 of the Legislative Aids Appointment Law of Delta State 1999 as amended, and claimant's letter of appointment dated 21st October 2019, is entitled to the security of tenure of office, simultaneously enduring with the tenure of office of first defendant. In Petroleum and Natural Gas Senior Staff Association of Nigeria, Pengerson, versus Academic Staff Union of Nigeria, ASU, and others. This court heard per Kanyip PNICN thus. I'm quoting PNICN now. The task of interpretation of laws and documents may be judicial, not executive function. Yet, the executive must understand or interpret the law in order to execute it. Even at this, the interpretative views of the executive remain views and subject to the overriding interpretation of the courts. Much in Mr. Ugochukwu Duru versus First but binding on this court. in terms of its claim before the court. I must point out that it is wrong for counsel to the claimant to assume that it is for the Honorable Attorney General of the Federation to tell this court what the orders of the Federal High Court signify, state, or enjoin. Whatever interpretation the Attorney General of the Federation gave to the orders of the Federal High Court remain the views of the Honorable Attorney General of the Federation on the issue, certainly not one binding on the court. And in Mr. Obasa versus Federal Ministry of Power, Works and Housing, this court heard the Kanyip PNICN that the interpretation of a witness, it is also versus National Intelligence Agency and two others. See also Gochuku Duru versus First Guarantee Pension Limited. The citations are in the judgment. Exhibit A, titled Appointment as Legislative Assistance, states in paragraph 2 as follows, quote, your appointment, which is at the instance of the honorable lawmaker, is tied to his tenure and attracts the following salary and allowances. Close of quote of that paragraph. What paragraph 2 means is that the appointment letter, appointment is said to be coterminous if the said appointment is issued to a person whose tenure is limited to a period specified by law or whose continuity in the service is based on the head of the organizational unit where assigned. For the claimant, the appointment is coterminous with first defendant as his tenure is limited to the period specified by law and whose continuity in the service is based on trust and confidence of the first defendant, that is the appointing officer or authority, a member of the Delta State House of Assembly. That means the claimant's employment has the same pattern and feature with the first defendant. The talk of claimant sustaining his position at the pleasure of first defendant is only sustainable on the basis of trust and confidence and subject to the claimant's letter of appointment, which I heard earlier is the bedrock on which any employee can lay claim to being an employee of the employer. And without the production of such a document, no employment can be inferred. CFG limit another, supra. By the intendment of Section 3 of the Legislative Aids Appointment Law of Delta State, 1999 as amended, and the letter of appointment of the claimant, that is Exhibit A, as legal assistant to first defendant, it is my considered view that subject to the issues of trust and confidence, the claimant's appointment is contemporaneous with first defendant's tenure, and I so hold. Claimant issue 3 challenges the stoppage of his salary with effect from May 2020. The defendants by the defendants without a fair hearing as guaranteed by Section 33, 34, 36, and 44 is not unconstitutional, nor void, and of no effect. In reaction, first defendant denied infringing on the claimant's right as claimed that the claimant's appointment was terminated as a result of his absenteeism, that the infringement on the claimant's fundamental is ancillary to his claim for unlawful termination of his employment. And as such, this court lacks the jurisdiction to entertain same. That the law is settled, that the principle of fair hearing is not magical, and not a magical one that can be applied to all cases. He cited a case that was not supplied in the final address. Exhibit D2, that is termination of appointment, as my legislative assistant, dated 13th May 2020, but takes effect from May 2020. What this means is that the termination of claimant's appointment is with retrospective effect. Exhibit A, that is appointment as legal assistant, issued to claimant dated 21st October 2019, did not state any notice period. That the appointment of claimant as legal assistant to first defendant is made pursuant to the Legislative Aids Appointment Law of Delta State 1999 as amended clearly indicates that it is one said to enjoy statutory flavor. See Oak Pension Limited and others with solar income, which heard that an employment is said to have statutory provision which are governed by statutory provision because the contract of service incorporating the terms and conditions is contained in the provisions of a status. Of a statute or regulations derived therefore, thereby vesting the employee with a legal status higher than the ordinary one of master and servant. See Shitabe versus FCS. Imolame versus Waik. Idoni Boye Obu versus NNPC. And Ibama versus SPDCN Limited. The common law is clear that an employer cannot terminate without notice. For where no period is given, the law demands that reasonable notice be read into the contract of employment. And this applies even in cases of probation. See Layinka Kusamoto versus Wemabod Estate Limited, where the Supreme Court stated the law thus. I'm quoting the Supreme Court now. The law is that generally, the length of notice required for termination of contract of employment depends on the intention of the parties, as can or may be gathered from their contract. And in the absence of any express provision, the courts will always imply a term that the employment may be terminated by a reasonable notice. That is from either of the parties. And even where, as provided in clause 21C of Exhibit B, for persons still under probation, the employer has power to terminate the contract in his absolute discretion. The law enjoins the employer to give reasonable notice to the employee. See African Association and Allen. Citation is there. The retrospective notice given by the first defendant in Exhibit D2, dated 13th May 2020, to take effect in May 2020, is certainly not a reasonable notice in the instant case, and I so hold. For not giving a valid notice to the claimant, the termination of his employment by the first defendant is wrongful. To this extent, Relief 3 has been proved, and so is hereby granted, but only to the extent that the termination of the claimant's employment is wrongful, and I so hold. Issue 4 is whether the payment of claimants' salaries and other emoluments by Delta State Government of Nigeria up to April 2020, excuse me, into claimant salary account and the subsequent proceeding of claimant's pay slips with claimant's employment data does not constitute the presumption of the continuance of employment in favor of claimant. The decision of this court in issue 3 forecloses any consideration of issue 4. In relation to issue 4, even if the question posed and the issues raised were answered in favor of the claimant, this relief, that is one for special damages, is one that cannot be granted via an originating summons. Issue 5 is whether the act of payment of claimant of CFO counterpart funding for the building of market stores and payment of outstanding electricity bills consumed by Ute Erumu community and the various acts of publicity stunts employed by claimant to attract public attention, interest, awareness, and support to first defendant's cause in Ute Erumu community and its environs, performance of the agreement entered into by first defendant and claimant, on which specific acts ensured the massive support and vote for the first defendant into Delta State House of Assembly for a second term does not constitute sufficient legal interest in claimant's employment and job security capable of extinguishing first defendant's inordinate power of instigating, directing, or instructing the withholding, stoppage of claimant's salary and other emoluments, and or constructively terminating claimant's employment at first defendant's pleasure. The claimant's reliance on Exhibit E attached to claimant's affidavit in support of originating summons, which is the computation by the claimant of list of his charity projects he could remember from November 2015 to May 2016, to establish that he entered into an agreement with first defendant on 20 August 2015 and second defendant 2015, 2nd December 2015, respectively, to carry out the activities or projects in exhibits E, F, and G are not helpful. This is so because the claimant's deposition, paragraphs 37 to 39 of the affidavit in support of this originating summons, that he entered into an agreement with second defendant on 20th August 2015 and 2nd December 2015 for claimant to spend his hard-earned money in carrying out some publicity stunts is not placed before the court. In Attorney General Rivers State versus Attorney General Akwa Ibom State, the citation is there. The Supreme Court heard per Muhammad JSC thus, I am quoting now, agreement generally is made when one party accepts an offer made by the other. It must be certain and final. Agreement can be signified through writing or by oral agreement, depending on the circumstances in which the contracting parties find themselves. Where it is expressly in writing, the general rule is that the court will not look beyond that writing to determine what its express terms are. Where the contract or agreement is made orally, the ascertainment of its terms is pure question of fact. Close of quote. In paragraph 18 of his amended counter affidavit to the amended originating summons filed on 11th December 2020, first defendant denied instructing the claimant to engage in publicity stunt, community projects, or humanitarian services on his behalf. That claimant did not spend or donate any sum of money whatsoever on first defendant's behalf. Regarding Exhibit E, that is list of claimants' charity projects, this court heard in Mr. Gabriel O. Obahiagbon and others versus the President, Federal Republic of Nigeria and others as follows. Quote, now, the claimant's claim is that they were short paid in their pensions. In proof of this payment shortfalls, claimants tendered Exhibit GO5E, Exhibit GO5A. However, the claimants purported payment record analysis and pension payment record prepared by G.O. Obahiagbon, that is the donee services. In essence, the first defendant. Since these exhibits are self-generated, they cannot be proof of any entitlement. At best, they qualify as pleadings. And Mr. Olapade Samuel Olatunwo Oyebola and others versus FAN, F-A-A-N. This court heard thus on self-generated exhibits. Exhibits C14 and C15 are the computation made by the claimants themselves as to their respective 2006 furniture claim and severance claim. Exhibits C14 and C15 are self-generated and so cannot be proof of the claimant's claim of 23 Conde Energy Limited and another. In like manner, Exhibit F, that is list of charity projects by the claimant, no proof of the claims therein. I so hold. This means that Relief 5 has not been proved and cannot be granted. I so hold. By NNPC Pension Limited versus Vita Construction Limited, the general rule is that costs follow events, and a successful party is entitled to costs. The award of costs or refusal to award costs is at the discretion of courts, provided the court's discretion must be seen to have been exercised judicially and judiciously. CUBN Limited versus Okolo, Stanbilini, Visioni Limited versus Malison and Partners Limited. The citations are in the judgment. It is not in doubt that materials or facts placed before the court aids it in exercising its discretion properly. Having heard that termination of the claimant's appointment is wrongful, it is my determination that the claimant is entitled to damages. I so hold. The payment of compensation, outstanding salaries, and emoluments are not grantable, and I so hold. The objection and issues for determination in respect of the substantive suit raised by first defendant were replicated and argued by the second and third defendant. All that I have stated in this judgment corporately encompasses all the defendants in this suit. More so, as all defendants are defended by the same law firm. Given the answers to the questions posed by the claimant and the reasons adduced thereby, I rule thus in respect of the reliefs claimed. Relief 1 is not granted. Relief 2 is not granted. Relief 3 is not granted. Relief 4 is not granted. Relief 5 is not granted. Relief 6 is not granted. Relief 7 is not granted. Relief 8 is grantable in terms of wrongful termination. Relief 9 is not granted. Relief 10 is granted. I declared and heard that the retrospective termination of the claimant's appointment by first defendant is wrongful. Claimant is accordingly entitled to general damages in that regard, which I hereby assess at 5 million naira only, payable by the defendants. Accordingly, it is hereby ordered that the first, second, and third defendants shall within 30 days of this judgment jointly pay to the claimant the sum of 5 million naira, being general damages for wrongful termination of appointment of the claimant. Judgment is entered accordingly. I make no order as to cause.
As the court pleases. My Lord, I'm grateful for the judgments given, and I would like to use this opportunity to apologize for the bad network I faced when I was trying to enter my appearance for the second and third defendants.
No problem. That's all right.
Okay. Thank you, my Lord.
Very well. You're welcome. Case number 2 is NICN Sabat 24/2019, Dr. Adaobi Jessica Tiemu and Delta State University.
May it please my Lord, Chinwe Umeche for the claimant.
What's the name again, please?
Chinwe Umeche, my Lord.
For the claimant.
Yes, my Lord.
Would you spell the surname, please?
Umeche.
Okay. For the claimant.
Yes, my Lord.
Yes, who is appearing for the defendant? Any appearance for the defendants?
Mrs. M.I. Osobwe. With me for the defendant. With me for the defendant is Mrs. Esther Imudia.
Very well.
Yes, my Lord.
I have carefully considered the processes filed and the arguments of counsel to the parties in this suit. I start off with the preliminary objection. The respondent's preliminary objection is premised on the grounds that there are substantial disputes on the facts of this case, which are irreconcilably in conflict and cannot be determined by the affidavit evidence alone in an originating summons, but ought to be resolved by oral evidence via writ of summons and statement of claim. Respondent had submitted that paragraphs 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27 of the claimant's applicant's affidavit in support of the originating summons are laden with allegations by the claimant applicant against the respondent which allegations oral evidence for the to cross-examine witnesses testifying against it, cited assault versus Inek and Fanfa Oil Limited versus AGF. Citations are in the judgment. In reaction, the claimant submitted that she seeks the interpretation of the specific provisions of bond form executed between the claimant and the respondent. On 28th January 2014, particularly Article 3, Sub 7 thereof, that she further seeks some reliefs arising from the interpretation of the said bond, cited Papa Company Limited versus Ocean Waves Corporation Limited and another. The claimant further submits that she suffered damages as a result of the actions and or inactions of the respondent and is entitled to all the reliefs sought. Claimant then urged the court to grant the relief sought by her in this suit. With claimant's particularity to Article 3(7) of the bond form, and whether a party can claim a right upon fulfillment of one out of several conditions precedent, which must coexist. Supreme Court in Africa Insurance Development Corporation versus Nigeria Liquefied Natural Gas Limited, heard per Ayola JSC thus. I'm quoting Ayola now. Where in the proceedings, the right claimed by a party to seek relief must be based on satisfaction of several conditions which must coexist, it is futile to claim a right of one of such conditions. Close of quote. The reliefs sought by the claimant in the claimant also seeks orders of court and damages. With relief D, which is a claim for all the benefits contained in Article, a claim for normal salary and allowances under Article 4, Sub 1 and 3 of the bond form pertain to reservation of claimant's residential house and official office, which claimant said were both converted to other use, matters of fact that require proof. Claimant's further affidavit in support of the originating summons, especially at paragraph 23 thereof, that the only reason the respondent wanted the claimant to return to the university was because the management embezzled part of the grant which the federal government allocated to her, which the respondent has failed and or refused to release to her to date, is a monetary claim that requires proof by the claimant. A claim for 15 million naira under relief B as cost of this case. It's also a claim for a fee which must be specifically pleaded with distinct particularity and must be strictly proved. In Ene versus Ozo and another, the apex court heard thus: the law is well settled. I'm quoting the Supreme Court now. The law is well settled that special damages must be specifically pleaded with distinct particularity, and it must also be strictly proved. This court should not act within the realm of conjecture in awarding special damages, and also should not rely simply on fluid and speculative estimate of alleged loss or injury sustained by the plaintiff. In proof of special damages, the claimant must therefore lead evidence to prove the type of damages of such a character as would suggest that he is indeed entitled to such award under the head, close of quote. The law by Honica Sawmill Nigeria Limited and Hoff. Between an employee, the onus is on the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only by the employee in the relevant period, but also how much the salary that he paid the employee was. Proof of all this can only be by pleadings, not originate, are quite specific that where a suit raises a substantive dispute of facts or is likely to involve substance by way of originating summons by complaint. See order 3, rules 8, 9, and 17, sub 2 of NICN rules 2017. See also Silvanus Eze, Viable, JSC, delivering the lead ruling, said, so once a suit has been filed by originating summons, and it becomes obvious that facts are in dispute, or the proceedings are likely to be hostile, the writ of summons would be ordered, close of court. On the whole, I am persuaded that this suit was inappropriately commenced using the originating summons procedure. That being so, it is my finding that this suit is improperly initiated by way of originating summons by the applicant respondent. There is accordingly no competent originating summons suit before the court. I so hold. Assuming, however, that I am wrong, and having heard both parties in terms of the substantive originating summons, I shall proceed to consider the merit of the claimant applicant's case. To the claimant, the fulcrum of this suit is centered on the interpretation of Article 3(7), sub 7 of the bond form, which provides that in the event of the failure of the claimant to resume duty after completion of the leave study or failure to comply with the prescribed duration of the work upon resumption, the claimant may refund all the salaries and any other expenses expended on her by the respondent. For this, we may have to take a closer look at the two questions posed in the originating summons in order to ascertain if what the claimant brought to this court is an action for interpretation. Question 1, in the originating summons quoted earlier at paragraph 6, 59 of this judgment states thus: whether from the clear, express, and unambiguous provision of Article 3, sub 7 of the bond form, the respondent has the requisite power to go outside the provisions of the bond form by issuing query and demand the appearance of the claimant before the respondent's senior staff disciplinary committee in relation to the alleged breach of the terms of conditions of the bond form. A closer look at the claimant, particularly headed terms of study leave, clearly indicates that the claimant has zeroed in on question 1. To the exclusion of the other study leave that make up the entirety of the 7th form terms of the claimant's study leave. On whether extrinsic evidence can be admissible to vary the terms of a written contract. The Supreme Court heard in B.O. Lewis versus United Bank for Africa PLC. The citation is there. Pel Okoro JLC here does, quote, the general rule is that where the parties have embodied the terms of their agreement or contract in a written document, the extrinsic evidence is not admissible to add to, vary, subtract from, or contradict the terms of the written instrument. See Mrs. Lyode versus Panapina World Transport Limited, Union Bank of Nigeria Limited versus Ozigi. The citations are in the quotation. I, however, observe that the bond form filed by the claimant in this suit is not signed or endorsed by the respondent. Can there be an implied adoption of the said bond form by the subsequent conduct of the parties? On this, the Apex Court in Idigbe versus Niger Motors Limited heard per Elias JSC does, quote, that there can be an implied adoption of the agreement by the subsequent conduct of the parties in their dealing with each other is borne out by the following passage from the judgment of Lord Evershed, M.R. Master of the Rolls. In McDonald showed that the judge said the facts show that the original so-called deed was executed as such by the plaintiff and by the father, but was not executed as a deed by the master. From the date of its execution, however, it seems to me plain that the defendants regarded themselves governed in their relations to the plaintiff by the terms of the deed, and they took the benefit of it and of such services as he rendered, as is shown by the circumstances that the defendants supported the apprentice's application for deferment. On those facts, I think that the two cases that Mr. Thompson cited in opening, Rex versus St. Peter's on the Hill and Rex versus Fleet, are authorities with the view that though the defendants did not execute their deed, they must be treated as bound by it, as if they had executed it. So by the authority of Idigbe versus Niger Motors Limited, Supra, and the conduct of the parties in this suit, it is my conclusion that they must be treated as bound by the bond form, as if they had executed it since the commencement date of 28 January 2014. Relying on Article 3.7 of Exhibit B of the bond form, dated 28 January 2014, the claimant argued that on 7th October 2019, the respondent issued him a query on the ground that she had breached the terms of her study leave. That respondent invited claimant to appear before the Senior Staff Disciplinary Committee to answer to the breach of the terms of study leave, of her study leave. That she responded to the query and in her response raised the issue of obvious violation of Article 3, sub 7 of the bond form by the respondent. But the respondent maliciously began the process of deducting the salaries of Dr. Joseph Edwin, whom the respondent assumed to be claimant's guarantor. Dr. Jero. That Dr. Jero Edwin merely signed the bond form as a witness to the transaction and not a guarantor. The respondent has no power whatsoever to issue query and invite her to appear before the respondent's senior staff disciplinary committee for alleged breach of terms and conditions of the bond form. In proof of the wrongfulness of the query and invitation to appear before the respondent's senior staff disciplinary committee, claimant referred to Exhibit B, C, D, E1, and E2. Exhibit B, dated 7th October 2019, is respondent's letter to American University of Malta. Exhibit D is the respondent's invitation letter to claimant to appear before the respondent's senior staff disciplinary committee. Exhibit E1, dated 09/07/2019, is claimant's medical report. And Exhibit E2, dated 10th October 2019, is claimant's reply to the query issued to her by the respondent, dated 7th October 2019. Exhibit E2, being a letter from the claimant to the respondent, in which she stated thus, I am quoting the claimant now, I apologize for being absent from DELSU, which is quite unfortunate, quite unintentional. Yes, I finished my PhD in 2016, but had my graduation ceremony in July 2017 at the University of Huddersfield. After my graduation, I wanted to do a postdoctorate to enable me acquire more experience. Cannot be proof of wrongfulness of the query. The authorities are pretty clear that accusing an employee of misconduct, etc., by way of a query and allowing the employee to answer the query, and the employee answers it before a decision is taken, satisfies the requirement of fair hearing or natural justice. See Monica versus Unity Bank PLC. See also Federal Medical Center, Ido Ekiti, and others versus Kolawole. See also Nigerian Maritime Administration and Safety Agency, as NIMASA versus ODE. The citations are in the judgment. The claimants claim in issue 1 that the respondent does not have the requisite power to go outside the provisions of the bond form by issuing query and making demands on the claimant having regard to Article 3.7 of the bond form is absolutely of no moment. Firstly, the challenge of the respondent's administrative authority over the claimant in the bond form does not rest in Article 3, sub 7 of the bond form on whether a party can claim a right upon fulfillment of one out of several conditions precedent which must coexist. I cited the case of African Insurance Development Corporation versus Nigeria Liquefied Natural Gas Limited, SUPRA, earlier as authority in stating that, quote, it is futile to claim a right by establishing satisfaction of only one out of such conditions, close of quote. Secondly, by the provisions of Article 1, which stipulates the authorized period of study and the conditions and terms of study leave. The thing is, if the employee takes longer than the bond form provides, then the employee is not only not entitled to pay, but also possibly in breach of the instrument. Article 3, sub 7 of the bond form is inserted for employees or officers who circumvent the terms of the bond, that is the study leave, and proceed on prolonged spells of leave due and admissible to them, and do not put in active service for the requisite period as stipulated in the bond executed by them. Whereas in Article 1, sub 1 of the bond form, the university has approved regulations governing the service of both senior and junior staff of the university. The employer cannot be faulted for proceeding against the employee as in the instant case. It is more so where the claimant contemplated a postdoctorate to enable her acquire more experience after her graduation, contrary to the interest of the defendant that the employee or staff acquire higher degree or professional qualification as contemplated in Article 1, sub 2 of the bond form, that is Exhibit A. In paragraph 3.9 of her written address, the claimant stated that, quote, the respondent maliciously began the deduction of Dr. Jero Edwin's salaries in a desperate bid to recoup the money purportedly expended on the claimant during the study leave, without first requesting the claimant to refund the money. It is either that the claimant or counsel to the claimant did not scrupulously read through the bond form, that is Exhibit A, or they are clueless as to what a bond is or what it means in law. Black's Law Dictionary, 10th edition, at page 211, defines bond as, quote, an obligation, a promise, a written promise to pay money or do some act if certain circumstances occur or a certain time elapse. A promise that is defeasible upon a condition subsequent, especially an instrument under seal by which a public officer undertakes to pay a sum of money if he or she does not faithfully discharge the responsibilities of office. Or two, a surety undertakes that if the public officer does not do so, the surety will be liable in a penal sum. Close of quote. Sylvester E. Quindry, in the book Bonds, the bondholder's rights, remedies, section 2, at 3 and 4, 1934, inserts thus, I'm quoting Sylvester now. The fact that an instrument is called a bond is not conclusive as to its character. It is necessary to disregard nomenclature and look to the substance of the bond itself. The distinguishing feature of a bond is that it is an obligation to pay a fixed sum of money at a definite time with stated interest. And it makes no difference whether a bond is designated by that name or by some other, if it possesses the characteristics of a bond. There is no distinction between bonds and certificates of indebtedness, which conform to all the characteristics of bonds. Close of quote. In Chami versus United Bank for Africa PLC, the Supreme Court heard per Onogen JSC, as he then was, thus, I am quoting Justice Onogen now. It is settled law that where a person personally guarantees the liability of a third party by entering into a contract of guarantee or suretyship, a distinct and separate contract from the principal debtors is thereby created between the guarantor and the creditor. The contract of guarantee so created can be enforced against the guarantor directly or independently without the necessity of joining the principal debtor in the proceedings to enforce same. See Olu Jiton versus Oshatoba. In Treaty on Contracts, I'm quoting the same Justice Onoge. In Treaty on Contracts, 24th edition, volume 2, paragraph 4831, the law is stated thus, quote, prima facie, the surety may be proceeded against without demand against him, and without first proceeding against the principal debtor. See also Moschi versus Leb Air Services Limited, Esso Petroleum Company Limited, and Alaston Bridge Properties. The citation is there, and I close the quote of Justice Onoge. The claimant's argument that Dr. Gerald Edwin merely signed the bond form as a witness to the transaction and not as a guarantor, in my considered view, is not tenable, having regard to the law as stated, especially in Chami versus United Bank for Africa PLC, Supra. The deductions in salary of Dr. Gerald Edwin by the respondent, therefore, is not in breach of the provisions of bond form executed with the respondent, and same is legal and not arbitrary or oppressive whatsoever. I so hold. Having considered the submissions of the claimants in issue 1, I do not see any merit in the claimant's argument that the provisions of Article 3.7 of Exhibit A, that is the bond form per se, rob the defendant of the power to query and take disciplinary actions against the claimant. More so as the claimant answered the query, the said query, with apologies. The argument of the claimant in that regard lacks merit and is thus dismissed. For issue 2, claimant argued that courts have for a long time awarded damages to assuage pains, suffering, trauma, or hardship caused by a party to a suit. See COPEC Constitution Limited versus Kisola, McQueen versus Emirates Airlines, and GKFI Nigeria Limited versus Snyder PLC. The claimant argued in paragraph 4.2 of her written address that she suffered damages as a result of the actions of the respondent. The particulars of the said damages were not pleaded nor proved to warrant the declaratory reliefs sought. See Okoye and others versus Wanko on the principles governing the grant of declaratory reliefs, which states that, quote, in action seeking a declaratory relief, the court can grant the relief, but subject to certain conditions. See Sunday Eguawense versus Amashizawen, Bunike, and another versus Mohunwoku. The citations are in the quotation. Faced with a declaratory relief, the court draws inspiration from consecrated principles, one of which is that the party seeking the relief must lead evidence upon which the relief is granted or denied, notwithstanding any admission in the defendant's pleading. The court has to be satisfied on the evidence led by the plaintiff that he is entitled to the relief he seeks. See Motunwashe versus Sorumbe, close of quote, after the citation. There being no proof of the declaratory reliefs sought by the claimant, reliefs A, B, C, D, E, and F fail and are dismissed. Undoubtedly, general damages are such that the law presumes to be the direct, natural, or probable consequence of the act complained of. I am not satisfied that the claimant is entitled to general damages, there being no proof of acts complained of. Relief G fails and is dismissed. Relief H is a claim for 15 million naira only as cost of this case. By NNPC versus Cliffco Nigeria Limited, the decision of the Supreme Court in that case, after the citation in the judgment, is that, I quote, evidence ought to be led before an award for special damages. To succeed in a claim for special damages, it must be claimed specially and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. Special damages are exceptional in character, and so there is no room for inference by the court. Relief H is a claim for cost. Of this case, there being no proof of same before this court, as stated in the case of NNPC versus Cliffco Nigeria Limited, Supra, Relief H fails and is accordingly dismissed. On the whole, claimant's case fails for lack of proof. Case is accordingly dismissed. Judgment is entered accordingly, and I make no order as to cause.
We are most obliged, my Lord, for the well-considered judgment.
My Lord, we are grateful to His Lordship for the industry the Lordship put in place to arrive at this judgment. We appreciate, my Lord, for the energy and all the painstaking efforts to arrive at this judgment. We are grateful, my Lord.
You're welcome. is NSCN OCA 04/2022. Dr. Lucky Edewo versus Dr. Tommy Okon and another.
May, my lord. May I please, my lord?
Yes.
Abiodun Akanji.
Just give me a minute. Give me a minute, please.
Very well, my lord.
Give me a minute. Give me a minute, please. Give me a minute. Yes, who's appearing for the claimant? Appearance for the claimant?
Yeah, may it please, my lord.
Yes.
E.N. Ifem. N as in Nigeria.
Sorry, E.N.?
E.N., yes.
Yes.
N. Yes. Ifem, I-F-E-M.
Yes.
My appearance is for the claimant.
Yes.
May I please, my lord?
Yes.
My appearance is for the first and second defendants, my lord.
Biodun who? Akombi?
Akoni is per AKA, my lord. Double N-I. For the first and second defendants, my lord.
Very well.
Yes, my lord.
This is my ruling. I have given due consideration to the processes and submissions of the parties. Firstly, I need to remark that the structures of the claimant and the defendant's written addresses are littered with poorly constructed sentences and expressions. For instance, there is to be found in the address of the claimant expressions such as, I am quoting now, the answer to the sole issue for determination as formulated by the claimant's respondents. I've looked at the processes filed in court. I don't see where there are many claimants or respondents. Can only see one claimant and one respondent. That this court, also say that this court has not been diversed. Don't know what that word means. Diversed, D-I-V-E-R-S-E-D, diversed of its constitutional functions. And what is diversed in the sentence is questionable, it's unfathomable. The claimant has shown that what is before the court in their claim, the still in plural, in their claim. How can claimant's claim be their claim? The claimant's written address in opposition to defendant's respondent's preliminary offense order 45, rules 2, sub 2, 3, sub 1, and sub 2 of the NICN rules 2017, which stipulates that a written address shall be set out in paragraphs and numbered serially, and shall contain a list of statutes or laws to be relied upon, authorities referred to, together with citations of the authorities, that all written addresses shall be concluded with a numbered summary of the points raised and the parties' prayers. Order 45, Rule 3, Sub 2 of this court's rules concludes that failure to comply with Rules 2 and 3, Sub 1 of this order may render the written address incompetent. This scenario is replicated in the claimant's written address in support of motion on notice, as I observed. Therein, claimant's argument under the first item of proof it states thus, saying what it states now, quote, the claimant applicant have been able, is one claimant applicant have been able When you're talking of one claimant, you're saying have instead of has. These are elementary things that one shouldn't see in a lawyer's written address. Claimant / applicant have been able. Under point 2, paragraph 2, claimant stated that the claimant's applicant, going by averments in the affidavit, have shown is one claimant. You're saying the claimant have shown. You're saying have when there's only one claimant. If there were many, it's a different thing. But when you say the claimant have shown, that's not good English. Were it not on grounds of interest of justice, this court would not have hesitated to evoke the provisions of Order 45, Rule 3, Sub Rule 2 of NICN rules in sanction of the claimant. In paragraph 3.9 of defendant's written address in support of preliminary objection, it is stated thus, and I am quoting now: an action is said to be incompetent where the required factual situation that could give rights, that could give rise to a cause of action do not exist. Sentence is terrible. It's in my ruling. You read it. In paragraph 3.10, lines 3 and 4 thereof, the defendants state thus, and I am quoting defendants now: claimant contends that the posting ought not to have been made and that the court should not give effect to it and restrains the defendant. Restrains the defendant. In paragraph 3.12, the defendant states thus, quote, we submit that an employer is duty bound to issue a query where it founds instead of finds, founds the behavior of an employee unsatisfactory. So it is either found or finds, not founds. The things that lawyers should be on the lookout. Doesn't tell good about counsel. In Shesha versus Ibrahim, the Court of Appeal heard per Abiru JCA does. This is what the Court of Appeal said. I'm quoting Court of Appeal now. The citation is in the ruling. Counsel must have a good drafting skills. Drafting is an important tool in who cannot present his client's case clearly in a brief of argument cannot adequately represent the interest of his clients. An otherwise good case can be destroyed and lost by bad drafting. The good case can be lost by bad drafting. The need for a counsel to display proper legal training in the preparation of court processes was emphasized by Aderemi, JCA, later JSC, in MV Arabella versus Nigerian Agricultural Insurance Corporation. The citation is there. The learned justice stated thus at page 582, I'm quoting him now, to say the least, the above 5 issues raised by the cross appellant are very horrible. They do not indicate that a person with legal training has drafted them. It seems to me that an ordinary prose writer who has no learning in the profession of law will produce far better and knowledgeable issues than the above 5 issues. If the profession of law will not be subjected to ridicule, I think counsel of the type holding himself out as representing the cross appellant in this matter will do well to seek the assistance of able and well-learned senior members of the bar to always help in vetting whatever processes he prepares before filing same in the registry of any court. I close that quote. That was the observation of Justice Aderemi, JCA. He was later in the Supreme Court. The defendant's preliminary objection is premised on 3 grounds: that the complaint disclosed no course of action, that Exhibit B, that the action is incompetent, and the action is an abuse of court process. I will take these grounds one after the other. To the defendants, the basis for the course of action must be pleaded in the initial complaint in a lawsuit, e.g., tort, fraud, breach of contract, etc. Cited Ohakim versus Angbaso, Additional versus Ojo, that the averments of the claimant that the defendants are bent on punishing him are more presumptuous speculations which have been only countered by the defendants, that they do not disclose the justiciable claim against the defendants. Cited Doma versus Inig. The action of the claimant seeks declaratory relief, challenging action of the defendants. Claimants of his function and sidelining him for the electioneering processes, vindictive posting, claimant via a WhatsApp message, contrary to the ordinary course of posting as required by the public service rules. To this and other declaratory reliefs, claimant seeks the order of court nullifying the posting instructions, allowing claimants to serve out his tenure or term of office and to resume his office and duties as the branch secretary of Association of Senior Civil Servants of Nigeria. Paragraph 3.7 of their written address in support of preliminary objection, the defendant duly stated thus: the averments of punishing him, are presumptions, mere presumptions, speculations, which have been duly countered by the defendants. In Obimi versus Ololo and others, the Supreme Court heard per Ogundare JSC that I do not agree that a claim for a declaration of parties' right discloses no course of action. It clearly does. It is straight beyond citing legal authorities that before a matter is commenced for determination by the courts, there must be a course of action cognizable in law. Course of action being simply a factual situation, the existence of which entitles a person to obtain from the court a remedy against another person. The AG Federation versus AG Abia State. Citation is in the ruling. Therefore, facts to be pleaded must be facts which would establish the course of action before the court. When such facts disclose a course of action, are not necessarily a measure of success based only on the averments in the pleading, then it can be said that there is a reasonable course of action. The Imperial Homes Mortgage Bank versus Diva Consulting Limited. The citation is in the ruling. Having considered the facts and circumstances standing the factor of a measure of success, it is my determination that there is a reasonable course of action to be considered notwithstanding the strength or weakness of the suit. And I so hope. As such, this court has the second issue or ground of objection by the defendants is that the instant suit is incompetent. In arguing this ground, the defendants argued that the gravamen of post dated 3rd February 2022, issued by the association and claimant's employer, that the defendants did not issue the letter claimants post, the association did, and second defendant merely signed the letter. That by Rule 13, Sub 5, Sub 4, 5, 6, and 7 has the power to appoint, promote, discipline, dismiss, negotiate salaries and other terms and conditions of employment of staff, that the association is not a party before this court, so as to be bound by its decision. The University of Calabar versus ACM, supra, that an employer is duty bound issue a query where it founds the behavior of an employee unsatisfactory. See also NEPA versus Olagunju. In reaction, the claimant argued that by Section 7, Sub 1C of NIC Act 2006, this court has the jurisdiction to interpret trade union constitutions. That Rule 13, Sub 4 of the Constitution of the Association of Senior Civil Servants of Nigeria does not make arbitration a condition precedent to maintain an action that centers on employment, conditions of employment, and posting, which is the case at hand. In Atago, in the case of Atago versus Nwuche and others, the Supreme Court heard per Galadima JSC as he then was, now retired. Commencement of action does not necessarily make it incompetent. It does not matter whether the action was begun by writ of summons or by originating summons. What is most important is the question of justice of the case. See Famfa Oil Limited, this is Attorney General of the Federation, People's Democratic Party versus Abuka. Citations are in the quotation. The defendants had argued that they did not issue the letter of claimant's post. The association did. The second defendant merely signed the letter. The reliefs that claimant seeks from the court are reliefs against the defendants as alter egos of the association. Real parties in interest. For the circumstance, in the circumstance, it will be idle to think that this case is not maintainable against first and second defendants in this court. To strike their names out may water down or defeat the outcome of this case. Assuming claimant gets a favorable verdict. To my mind, therefore, the first and second defendants are proper parties before this court, and I so find and I hold. The third issue is whether this action is an abuse of court process and should be dismissed. That an abuse of court process occurs where an action is initiated without a just or reasonable cause. Ogboru versus Oduago, and TSA Industries Limited versus FBN PLC Supra. That it is clear from the originating process that the claimant has failed to satisfy the conditions precedent for bringing an action as enunciated in NNPC versus Rio Wasile. Citation is in the ruling. That it is clear from the authorities cited that an abuse of court process strips the court of jurisdiction. Claimant, on the other hand, maintains that he has shown that what is before the court in the claim and reliefs of the claimant totally revolves around the interpretation and application of the provisions, Constitution of the Association of Senior Civil Servants of Nigeria. In Dana Airlines Limited versus America and others, America and others, the citation is there. The Court of Appeal heard by George Will, JCA, that what would constitute or amount to abuse of court process is very diverse, imprecise, and thus subject to infinite or indefinite considerations. That in considering whether or not an action or process constitutes an abuse of court process, the court is to critically consider the peculiar facts and circumstances of each case in which the issue of abuse of court process is raised. And it largely depends on peculiar facts and circumstances of each case. See Ete versus Edohu, Ume versus Iwu, and Ukachuku versus PDP and others. The citations are in the judgment, in the ruling. The argument of the parties in the preliminary objection dwelt substantially on the substance of the main suit. Defendants should have rather focused on the substantive matter. On the whole, I hold that there are triable issues for determination on merits by this court. As such, this court has jurisdiction over it. Preliminary objection of the first and second defendants fail, so is hereby dismissed. I now proceed to the merit of the claimant's motion on notice for an order of interlocutory injunction. To the claimant, the defendants are bent on terminating his employment with the Association of Civil Servants of Nigeria, that all efforts to call the attention of the defendants to the unconstitutional nature of this act proved abortive, that his only sin against the defendants is his decision to remain neutral during the said election, that due process was not followed by the defendants, that the actions of the defendants are not in line with civil service rules, and the constitution of the association. To the defendants, the claimant is no longer the serving secretary, Delta State, as he had been transferred to the National Secretariat, Lagos. The claimant's opinion as to the capability the respondents to sack him are speculative and figment of his imagination. The claimant is confusing the respondents with the association who employed him. That the claimant was not neutral, but decided to support some candidates and not to work for some candidates perceived as defendants' candidates. That the defendants are the ones who are shocked that a representative of the association has a preferred candidate, thus causing chaos in the Delta State branch. That it is the claimant that refuses to follow due process by refusing to obey lawful instructions of his employer, the association, to proceed to its National Secretariat, Lagos. that it is not true that the defendants acted contrary to the association's constitution. I have given due consideration to the submissions of the parties. The essence of injunction is to protect legal rights or recognizable rights of a person from unlawful invasion by another, as long as the act which the applicant complains of will result in the infringement of his right, an injunction should issue, and it is immaterial whether no pecuniary damage is proved. An injunction shall be granted where loss cannot be adequately compensated by an award of damages. Generally speaking, interlocutory injunctions are granted to preserve the rest. It is the province of the law that the rest should not be destroyed or annihilated before the judgment of the court. See Akimpelu versus Adegbore and others. See also Achebe versus Mbanefo and another. The citation is in the ruling. On the purpose of an interlocutory injunction, Supreme Court, the case of the military administrator, Federal Housing Authority, and another, versus Arrow, citation is in the ruling. Bergore, JSC, she then was, head thus, I'm quoting Bergore now. It is therefore appropriate to state that interlocutory injunction is to mitigate the suffering of the party applying for it, so that he will not be in unnecessary hardship during the pendency of the substantive suit. It is always good to prevent injustice that must invariably could not be cured properly at the end of the substantive case if it was not granted. Property and Development Limited and another, versus Chevron Nigeria Close and Limited, and Ladipo, and others. The citations are in the ruling. So having considered the processes filed, especially the originating processes, the affidavits of both parties in support and against this application, the written addresses, the affidavit of urgency and undertaking, it is my determination that it will be in the best interest of justice to fast track the hearing and determination of this suit. In the circumstance, it is hereby ordered that the status quo ante bellum be maintained by the parties pending the hearing and determination of the substantive suit. This order shall be subject to review as the circumstances shall permit as the case goes on. Ruling is delivered, and I make no order as to cause.
We are most grateful, my Lord, for a well and precise ruling, and we take note of the English that you have pointed out in our addresses. We're most grateful, my Lord.
We're grateful, my Lord. I would also apologize for the errors pointed out to us. We thank my Lord for the ruling.
Now, counsel to the claimant and the defendant.
Yes, my Lord.
I made mention of fast tracking the determination of this matter. So I want both of you to pick like 2 or 3 dates that we would wrap up the case for the claimant, and then, if possible, open the case for the defendant so that we are done before the end of this year. That's my target, so that both of you can move on one way or the other.
Very well, my Lord.
About fast tracking. I was talking about fast tracking the determination of this suit, and then a review as we go on. I don't want to go beyond 2022. Let me be playing with both of you. I don't want to go beyond 2022.
My Lord, you will be guided by the diary, the court.
Can you people take a date or 2 dates in July? End of July.
Very well, my Lord.
My Lord, I have 26 July.
Sorry?
I have 26 July. Really on my diary. 26 July.
that okay for both of you? 26 July?
26 July is okay, my lord.
What about 27? 27 is Wednesday.
Yeah.
Before your little brother.
Okay, so 26 and what now? What about 28?
28 is convenient for me too.
My lord, if you are taking 28, I would prefer 2 dates together. So that, because I'll be leaving from Lagos, I'll be coming from Lagos now. 19, 21, 19 and 20 July. So that I can
19 and 20?
yes, my lord.
Yes. What about 19 and 20?
My lord, that would be okay. That would be okay. We just want this matter to go on as soon as possible.
That is why I did that ruling like that. So 19 and 20, it doesn't matter how. I don't have the diary of the other people, but it is okay. We will fix it in.
As a company, we are most grateful.
Yes.
I'm most grateful.
So this matter is adjourned to the 19th and 20th July 2022 for definite hearing.
As the court pleases.
Yes. Good. I think we're done. That will be all. The court will rise now.
Work on your grammar. But it affects both sides. You know what happened here? Why I'm not? Okay.